Hello, this is attorney Grant Toeppen from Manteca, California. I also have an office in Livermore, California. I practice estate planning and probate law. So the purpose of today's video is to explain the Small Estate Affidavit, what it is, how to use it, how to fill it out, etc. Okay? So before we go any further, I want to explain that nothing in this video is to be construed as legal advice, and nothing in this video creates an attorney-client relationship between you and me. Okay? So let's jump in. What is a small estate affidavit? A small estate affidavit is something that you use when someone died in California with under $150,000 in assets. Okay, you can use this instead of a probate in many situations to get money out of a bank account, an asset transferred, an annuity policy where the beneficiary died and you're dealing with the annuity company and they won't release the money. These are examples of when you would use this. A lot of the times institutions tell you that you need letters testamentary. If the estate is under $150,000, I suggest you revisit that assumption because they are frequently wrong and they just do not like to go down this path. So they don't tell you about it, although it is much easier, much cheaper, much faster. All right, so let's go through it. So, number one. The undersigned states as follows. So everything here will be under penalty of perjury. So let's make sure it's 100%. All right. So number one. So who died and what date did they die and where did they die? So let's make sure we don't upset anyone and make it so me who died. All right. So it's not some random name who then complains to me that I put their name up here. So Grant Alexander Toeppen died. All right. Notice I included the full name. I suggest you always include the full name. This makes it so there is less likelihood of rejection. If their account says that my name is Grant Alexander Toeppen and you just put Grant Toeppen or Grant A. Toeppen, guess what? You're rejected. This was for naught. Start again. Okay, so do the full name here. Died on. Let's give me a nice full life. Let's say I died on December 31st of 2099. It's a long time. I guess I was a cyborg or something. In the county of San Joaquin. That's where I usually practice. So let's put San Joaquin, state of California. All right. Number two, at least 40 days have elapsed since the death of the decedent, as shown in a certified copy of decedent's death certificate, which is attached to this affidavit or declaration. You can pick up a certified copy of a death certificate, typically at a county recorder where the person died, the county where they died, all right? And you can tell it's certified because you feel the bottom corner, and this is in California at least, the bottom right hand, sometimes the bottom left hand corner will have bumps on it, raised bumps. That shows that it is certified, okay? Number three, no proceeding is now being or has been conducted in California for administration of decedent's estate, or the decedent's personal representative has consented in writing to the payment, transfer, or delivery to the affiant or declarant of the property described in the affidavit or declaration. Let's turn these into English, okay? So number three is saying no probate happened, is currently happening, or as far as we can tell is going to happen insofar as this estate is concerned. That's usually the case. We're doing this to avoid a probate almost every time. But let's explain the second one. The second one is a probate is happening. The executor or administrator of the probate has consented in writing to the transfer we're asking for here. All right. So that's basically all that we have. And you want to make sure the personal representative or whoever signs a document you have in your records saying that they've okayed you to fill this form out and get paid from the institution you're asking for payment from. Okay. So number four. The current gross fair market value of the decedent's real and personal property in California, excluding the property described in Section 13050 of the California Probate Code, does not exceed $150,000. Okay, so let's make sure that we have the right number, is basically what this is saying. If you have a number that's 200,000, let's double check and see if there are assets in the estate that actually shouldn't be counted towards our small estate affidavit, $150,000. So you can just Google, California Probate Code section 13050. You'll get something like this. All right. So let me make this simple. I'm not going to bore you by reading each part, but in general, if the decedent held assets in joint tenancy, whether real property or another asset, that's not going to be counted towards the $150K. If they have a pay on death beneficiary or payee or something like that on an account, that account's not going to be included in the probate or in the number for the small estate affidavit. All right, we're not going to include vehicles. We're not going to include boats. We're not going to include manufactured home, mobile homes, commercial coaches, truck campers, or floating homes. We're also not going to include amount due for services in the armed forces of the United States, or if money was owed up to $15,000 of salary or other compensation to the decedent, we don't include that either. So let's make sure we use the lowest number possible when we are filling this out, so you're under the $150K and can avoid the probate, okay? Because if you're over it, you go into a probate. 10, 14 months in San Joaquin, $10,000 to $20,000 in attorney's fees is usually about where it lies. So let's try to avoid that. Let's go to 5. Once again, a choice. Either an inventory and appraisal of the real property included in decedent's estate is attached, or there is no real property in the estate. I'll check that box because it makes life easy, but let me explain the first one. If there is real property in the estate and that real property does not have a joint tenant or pay on death beneficiary, then you're going to have to do this first part, get the inventory and appraisal. What you need to do there is you can only get, let me emphasize, you can only get the inventory and appraisal from the probate referee for the county where the decedent was domiciled when they passed. So basically, you need to contact the county probate clerk or look on the county court's website, all right, to find out who the probate referee is. And then I just get the address, send them a letter explaining the situation. I include an inventory and appraisal form that I fill out the address of the property, the legal description of the property, the APN of the property on that inventory and appraisal, and I send it to the probate referee so that they can get me an appraisal that will then be used to further this small estate affidavit. All right. So then number 6, the following property to be transferred, delivered, or paid to the affiant under the provisions of California Probate Code section 13100. Okay, so this is where you list the stuff, all right? I typically only like to list one line item per small estate affidavit. In the past, I've used it for 2 or 3. I find that can confuse things sometimes, but I'll fill out a few just to give you an example, okay? You want to be as precise as possible here, because if you're not, you might get rejected, all right? So, Wells Fargo checking account number 54 blah blah blah, all right, or MetLife insurance policy, life insurance policy, contract number blah blah blah. Just make sure you're full and complete. Number 7. The successors of the decedent, as defined in Probate Code section 13006, is or are. So if there's more than one person who's supposed to inherit the asset we're talking about, like that Wells Fargo account in number 6, you're going to list more than one. The successor of the decedent, in this case, is just who the heck is supposed to inherit this property. So let's pretend that we have 2 people who are supposed to inherit it, Bob Smith and John Smith, okay? So let's put their names there. All right. How do you know who the successors are? Either they will be named in the will, or if there is no will, they will be the persons who are entitled to inherit under California's laws of intestate succession, right? You look at California Probate Code 6401 and 6402, and they'll show you the order in which if someone died without a wife, who gets the money. To explain it really roughly and incorrectly, in general, the hierarchy is spouse, kids, grandkids, other lineal descendants, parents, grandparents, and then siblings. It's a lot more detailed and complicated than that, and I will make a separate video. All right, but typically just look at the probate code section. You'll figure it out. So, number 8, the undersigned. Once again, a choice option. Either the affiant or declarant is the successor of the decedent, so either the person signing this is the successor, or the affiant or declarant is authorized under Section 13051 of the California Probate Code to act on behalf of the successor of decedent. So what the heck are we doing here if we check that second box, okay? Let's pretend that John Smith, listed above, let's pretend that he is mentally incapacitated and he has an agent under a power of attorney who would act for him. That person could sign off, as could a conservator or guardian for John Smith. If John Smith was under 18, you could have a guardian sign off for him. So that's what we're talking about with the second box. We'll just check the first one to make life easy. All right. 9. No other person has a superior right to the interest of the decedent in the described property. Basically, what we're saying here is, hey, you're not defrauding anyone or doing something sketchy here. You really are the person who's supposed to get this, right? Because if you're not, then you could have been committing perjury when you filled out this form, and you could have been committing fraud. And you will have a lot of questions to answer, and you may find yourself answering them to the police or a DA. So be careful there. Number 10, the affiant or declarant requests that the described property be paid, delivered, or transferred to the affiant or declarant. Basically, the person or people signing this thing are the ones getting it, all right? Then the final little thing here, the affiant or declarant affirms or declares under penalty of perjury under the laws of the state of California that the foregoing is true and correct, okay? So then for the signatures, let me fill the date. It's the 27th today. For the signatures, make sure that the person signs and then the name is printed next to their signature, or your documentation will be refused. Once again, make sure that when a person signs, the name is printed next to the signature. In this case, we have more than one successor, so we would have Bob and John Smith's signatures with their printed names next to it. This would also be notarized. Almost every form I find online has the incorrect notary form on it. You actually want the jurat. You do not want the acknowledgement, okay? Whenever someone signs an affidavit, they want a jurat, which is the one that says it was signed by under penalty of perjury. All right? This acknowledgement, 80% of the time, the bank or whoever you're dealing with won't know the difference. But in the small chance you're dealing with someone who does know the difference, which I would assume you will be, you want to use a jurat, right? Just Google California jurat, print it out, bring it to the notary when you have your complete form set. All right, so what you'll do is you'll complete this form. You will attach the notarial jurat. You will attach the certified copy of decedent's death certificate. When getting this to the institution, I suggest sending it both via certified mail and via fax. That way you have confirmation. They love to pretend that they did not get what you sent them. And if they unreasonably withhold these assets from you, they can be held liable for the attorney's costs in getting the assets from them. I'll include a template letter that I've put together, either in the subtext or on my website, and you'll be able to see also my strategy of escalation for dealing with these entities. All right, so once again, this is Attorney Grant Toeppen, probate and estate planning attorney based in Manteca, with an office in Livermore, and nothing in this video is meant to be construed as legal advice or create an attorney-client relationship between us. But I do hope that it helped you to demystify the small estate affidavit and how you can avoid a probate in some situations when using this, okay? Don't trust the institution when they say you need letters testamentary. They are wrong 3 out of 4 times in my experience if it's under 150K, all right? So have a good one and good luck out there, everyone.